Hello, today we will be talking about the landmark 1999 Supreme Court decision in the Olmstead case and what that means for people with developmental disabilities today. Any materials provided by Washington Civil and Disability Advocate, WACDA, are for informational purposes only and are not legal advice. WACDA is not responsible for the consequences of your reliance on any informational materials provided. Your use of informational materials does not create an attorney-client relationship or any other relationship or the expectation of confidentiality between you and WACDA. Views expressed in informational materials are those of the individual author and may not reflect the views of WACDA or its individual staff members. If you need legal advice, you must seek advice from an attorney regarding specific legal issues. Thank you. So to provide a little bit of overview of the case, it's a 1999 Supreme Court decision of Olmstead versus LC. Two Georgia women with intellectual disabilities were confined in a state psychiatric hospital despite medical professionals recommending them for community living. Olmstead was the name of the Georgia Commissioner of Human Resources, Tommy Olmstead. He was the defendant in this case. The plaintiffs sued the state officials for failing to place them in community-based programs, therefore violating their rights under Title II of the Americans with Disabilities Act, or the ADA. They asked the state to place them in community-based residential care programs, and they asked that the treatment have the goal of integrating them back into mainstream society. And they won! Yay! This decision helped create a precedent that continues to improve lives today. So these are the plaintiffs, the women that brought this landmark case. The first plaintiff is Lois Curtis on the left. Lois Curtis was diagnosed with mental illness and developmental disabilities as a child. She was sent away to live in an institutional setting around the age of 12 and was separated from her family and community for long periods of time. Due to her continued difficulties, she was sent back to the hospital, even further away from her community, and she spent her teenage years and early 20s in and out of different institutions, hospitals, and private care facilities. And by the time Lois was in her mid-20s, she spent over half her life shelved from facility to facility and segregated by her disabilities. Lois is social and loves art, but in her confinement wasn't able to express those things and was very frustrated and aggravated. She wasn't able to pursue her talent of painting. She would periodically call up Sue Jameson at Atlanta Legal Aid Society, who was the principal attorney for the case, and would ask her, "When can I get out of here?" Because she didn't belong there. The other plaintiff was Elaine Wilson. Elaine Wilson suffered from brain damage from a childhood illness. Because of the lack of community support, she lived in 36 institutions from the time that she was 15 to the time of the lawsuit. She said, "When I was in an institution, I didn't like myself. I felt trapped. I had no hope. I thought, oh God, when am I ever going to leave here?" Both women had asked the state of Georgia to help them find community treatment, but the state did not provide it, and these women were forced to spend most of their life in mental hospitals despite their doctors clearing them for community living. They didn't belong there, but they were stuck there with no other options. So these women brought suit against the state of Georgia to stop being segregated because of their disability. Now I will discuss some of the key legal provisions that shape the court's decision. The first law is the Americans with Disabilities Act of 1990. The ADA was passed in 1990 to protect individuals with all types of disabilities from discrimination. Congress stated that its goal in passing the ADA included the fact that despite having a right to fully participate in society, people with disabilities have historically been excluded and discriminated against. They also found that society has tended to segregate people based on disabilities and that it continues to be a serious and pervasive problem. These concerns that Congress intended to remedy with the ADA certainly align with Lois and Elaine's experiences and the experience of anyone with disabilities who has been unfairly institutionalized. Lois and Elaine sued under the ADA Title II. Because they were suing a public entity, the Olmstead case fell under Title II of the ADA. Public entities are local and state governments and their agencies. Under Title II of the ADA, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. Community placement and services would be part of the services, programs, or activities of a public entity that Lois and Elaine were being denied due to discrimination. The next part of the ADA that's important for the court's decision in Olmstead is the ADA integration mandate. Another responsibility of public entities under the ADA is to administer their services, programs, and activities in the most integrated settings appropriate to the needs of the individuals with disabilities. This is sometimes referred to as the ADA integration mandate. Integration in this context means that those with disabilities are integrated into mainstream society among those without disabilities as much as possible. Remember, Lois and Elaine's complaint was that they were being segregated from society instead of being integrated, something doctors agreed that they were very capable of. Another relevant part of the ADA is the idea of a reasonable modification. A public entity must make reasonable modifications in policies, practices, and procedures to avoid disability discrimination. The court decides what is reasonable and what it means for a modification to fundamentally alter the nature of the service. This is the most common defense used by governments when sued over Olmstead cases, and we'll talk a little bit more about this later. The Olmstead decision was decided at the Supreme Court in 1999. First, it went through the Georgia District Court and the 11th Circuit. Both of those courts ruled in favor of the plaintiffs. Then Georgia appealed to the Supreme Court, which granted the review that would set the Olmstead precedent. Supreme Court Justice Ruth Bader Ginsburg wrote the decision. In the Olmstead decision, the Supreme Court found that unjustified isolation, like the type of segregation that Lois and Elaine experienced, is illegal discrimination based on disability. They found that Georgia had illegally discriminated against Elaine and Lois because of their disability by requiring them to stay in an institution instead of living in the community. This was a form of illegal segregation under the ADA. The court definitively ruled for the first time that state and local governments must provide community-based services to people with disabilities when three circumstances are met, which will be discussed on the next slides. The court continued its reasoning by focusing on how society sees people with disabilities and how people with disabilities experience life in society. The court recognized that unjustified institutional isolation of persons with disabilities is a form of discrimination reflecting two evident judgments. First, it perpetuates unwarranted assumptions that persons with disabilities are incapable or unworthy of participating in community life. And it also severely diminishes the everyday life activities of individuals with disabilities. It limits their family relations, social contracts, work options, economic independence, educational advancement, and cultural enrichment. The court also pointed out that there were different illegal standards for people with disabilities versus people without disabilities when it came to medical care. Under the ADA, qualified individuals cannot be treated differently when they could participate given reasonable accommodations. Lois, Elaine, and others were being treated differently and had to make huge sacrifices and be separated from their community to get the care they needed solely because of their mental disabilities. However, people without those disabilities could get the medical care they needed without being isolated from society. The three Olmstead requirements for when state governments must provide community-based services are when, first, treatment professionals determine such services are appropriate. Remember, Lois and Elaine's doctors had cleared them for community living. Second, the person with a disability does not oppose the services or community-based living. And third, services can be reasonably accommodated, taking into account the resources available and the needs of other individuals with disabilities. This last requirement is the most ambiguous and the one most often litigated, so I will talk about this a bit more in depth. For reasonable accommodation under Olmstead, governments do not need to provide accommodations, in this case integrated community placement, that would fundamentally alter the nature of the service, program, or activity that the government is providing. The government only needs to provide what is reasonable. To determine what is reasonable, the court considers, in view of the resources available to the state, the cost of providing community-based care to the individual requesting the community-based care, the range of services the state provides to other individuals with mental disabilities, and the state's obligation to provide those resources equally. One example the court gave in the Olmstead opinion of a state not necessarily immediately placing someone in community-based living but still fulfilling its obligation of reasonable accommodation would be when the state has a plan set in place to move people into community living and has a wait list moving at a reasonable pace that's not controlled by the state wanting to keep people in institutions. So then the reasonable modification standard may be met. The state must have a legitimate plan with a reasonable waiting list. So we looked at what a state can say is a reasonable accommodation, but when can it claim that the cost of placing someone or a group of people in community living is so much that it would fundamentally alter the nature of the services they can provide and therefore become unreasonable? So a state raises a fundamental alteration defense, and then the court analyzes the defense. But in analyzing the defense, the court cannot simply compare the cost of institutionalization with the cost of community-based services, and it cannot simply compare the cost of requested services with the state mental health budget. Both of these restrictions stem from the concern for widespread compliance of a state versus an individual case-by-case solution request. Courts cannot simply compare the cost of institutionalization against the cost of community-based health services because such a comparison would not account for the state's financial obligation to continue to operate institutions for people that need them, that are not able to be placed in community settings. Furthermore, the state's mental health budget will almost always dwarf the requested individual relief, so it's not a fair comparison. The court cannot force a state with a legitimate plan for compliance to alter that plan for immediate relief to individuals if it would threaten the effectiveness of the overall plan. So the cases can get pretty complicated. In terms of the state's ability to establish the fundamental alteration defense, general budget concerns are not enough. They can't simply say it's too expensive. Although the state can point to past progress in deinstitutionalization, they also need to show a commitment to future progress through a plan. The case referenced at the end of the slide, Frederick L. versus Department of Public Welfare of Pennsylvania, was a class action suit against the State Department of Public Welfare by mental health patients institutionalized in a state hospital in Pennsylvania. The plaintiffs claimed that state failure to provide adequate community services violated the Americans with Disabilities Act and Olmstead. So where are Lois and Elaine now, after this landmark decision that has positively impacted so many lives? Elaine passed away in 2004 at 53 years old after experiencing a transformation since returning to the community. She had even started presenting her story and advocating for others. If you follow the YouTube clip on the left, you can see one of her attorneys from the case describing the transformation in Lois from when he first met her to after she started living in the community, and how staggering the improvement was in her life and her relation with others. And then the link on the right is a link to her obituary and a tribute to the importance of her life. Lois is still active in the community, living in a community setting, and she's an artist who sells her work and inspires people. And there's a picture of her being honored by President Obama. The Olmstead decision can be applied to a number of different scenarios regarding people with developmental or intellectual disabilities. One example is in the realm of employment. Some settings called sheltered workshops employ large amounts of people with intellectual disabilities, usually at low wages, lower than minimum wage, to do repetitive work. The sheltered workshops are controversial, with some people saying that this is a way for people who would not normally be employable to have employment, and other people saying this is segregation of people with disabilities. This is in contrast to competitive supported employment, where people with intellectual disabilities are out in the community working alongside people without those disabilities in an integrated environment and interacting with everyone else. Since the Olmstead decision, there have been a number of cases concerning sheltered workshops where plaintiffs have come forward and said that their placement in sheltered workshops versus competitive supported employment in the community is a form of segregation. There was a case in Oregon in 2012 with a number of plaintiffs who had been employed in sheltered workshops who were asking for community placement and were denied those community employment opportunities. The court there found that despite Oregon having the Employment First program and community initiatives and goals, they had lost momentum and were relying too much on workshop placement at the expense of supported employment for their citizens with intellectual disabilities. This was a class action suit asking for greater integrated employment opportunities. The court found that Oregon had to change their program to prioritize integrated employment for qualifying individuals and cited Olmstead. This is an example of Olmstead being used beyond just the scope of where people are living and really affects every part of people with disabilities' lives. Here are some sources and additional information about the Olmstead decision and its effects. The first website listed there, Olmstead Rights, gives a really good overview of the case and also the kind of advocacy that people are doing now regarding the Olmstead decision. And listed below are also the specific cases that are referenced in this presentation.